Where we run into the problem is, like you mentioned, the student loan debt is huge. It takes too much of their income and it keeps them from doing other things with their life that they might want to do, starting a business and all that.
Are you ready to make your law firm a profit-generating machine that will free up your time and skyrocket your impact? With more than 2 decades of business growth experience and having proven that you can be successful while prioritizing your family and your impact, introducing the Profit with Law podcast. I am your host, the creator of the firm differentiator 10x effect, 𝗖𝗍 𝗻𝘁𝘂𝗃𝗃. Well, hello and welcome to another guest interview here on the Profit with Law podcast. I'm your host, 𝗖𝗍 𝗻𝘁𝘂𝗃, and we're going to be talking about a topic that I really haven't covered here on the podcast, other than backhandedly slapping the notion or the idea of what's tying down some of our listeners. We really haven't addressed this topic at all. And I'm excited to jump into it because I'm a numbers guy, I'm a finances guy, and I love talking about anything that includes debt reduction, debt restructuring, or making it possible to have capital for investing in your business. So our topic today is going to be all around student loan debt. And we have the guru in the house. This is Christie Arkovich. She is the owner of Christie D Arkovich, PA. And she's been a Florida licensed attorney for 30 years since graduation from Stetson College of Law in 1992 with honors. Ms. Arkovich is a frequent speaker at various consumer-oriented continuing legal education seminars for other attorneys before the American Bankruptcy Institute, the National Association of Consumer Advocates, and the Tampa Bay Bankruptcy Bar Association. She also writes a quarterly column for the TBBBA, Student Loan Sidebar, not sure if I put an extra B in there or not, about recent student loan related laws, regulations, and developments nationwide. Whenever possible, Ms. Arkovich takes the opportunity to share her knowledge about student loans gained from prior work as trial counsel for Sallie Mae, 𝗖𝗹𝗹𝗃, and other student loan servicers or grantors, and from her practice now on the consumer side of things. She recently served on the student loan committee for the new student loan management program in the bankruptcy court for the Middle District of Florida and was chair of the consumer CLE for the Tampa Bay Bankruptcy Bar Association for 2019 to 2022. And on top of that, I just found out that she has started a playlist on YouTube that's under her Arkovich Law channel. So if you go to YouTube and search for Arkovich Law, subscribe to that channel, there's a playlist in there called Student Loan Sidebar, and it's a bunch of videos talking about some of the topics that we're going to cover today, maybe going more in depth in there. So I invite you to go and check that out. We will link that up in the show notes along with any other resources we discussed today. Those show notes can be found either in the description of your podcast player or on our website at profitwithlaw.com. Speaking of YouTube, we recently launched our own YouTube channel, and I invite you to go and subscribe there. We have additional content, more different than what we cover here on the podcast. And some of it, I flew down to Miami, Florida, and met with a production company, and we recorded video for 2 days straight and produced 46 videos out of that. We're releasing one a week over the course of the year. So it's going to be really good stuff, curated some of our best content for you. And I invite you to go and subscribe to our YouTube channel, the Profit with Law YouTube channel. Again, that will be linked in the show notes. That was a mouthful. So, Christie, welcome to the show.
Thank you. I'll be short.
All right. So when we start, what I like to do with my guests is, our listeners may not have heard of you. They may not know who you are, or they may know you very well. Give us the synopsis, not the script that I just read, but give us the story of how you ended up where you are today, and you know what excites you about the work that you're doing right now.
Okay, sure. Well, I first started out actually working for the other side. And back when I was a baby lawyer, one of my first clients was, I think it was Sallie Mae or USA Funds. And then it later became 𝗖𝗹𝗹𝗃 and some of the other servicers. And so we ran around the state of Florida. I was trying different cases for Miami, Tampa, Jacksonville, Orlando, and did a couple appeals with those. And I realized how hard it was for someone to get out of their student loans. Back then, it was extremely difficult, and it still is, but there's a lot of things going on in the past 2 years that a lot of listeners don't know yet about. So I think that could be helpful. But why I switched sides, we always had a bankruptcy practice alongside, and we constantly ran into student loan issues. And most attorneys, back when I first started doing this a decade or more ago, they pretty much said there wasn't anything you can do about student loans. They never talked about it. People would file bankruptcy. They wouldn't realize they still owed their student loans after the case was discharged. And it became just a snowballing effect with that debt. And at the same time, cost of tuition went up. Back in the 90s, 2000s, we had these schools charging 10 times what they used to charge back when I went to school in the early 90s. And people started graduating with, instead of a 1-to-1 ratio, when I graduated law school, I think I owed $45,000, and my first job paid $40,000. So it was basically a 1-to-1 ratio. Now I see grads with 8-to-1 ratios, for instance. And that's a debt that isn't easy to repay. You also have folks that maybe graduated during a recession, during the foreclosure crisis. And if you throw in years of forbearance, which is what we saw, you'd had a debt that might have started out to be 20, 30, 40, 50, 70,000. Now it's in the hundreds, and it keeps people from moving on with their life. And so it fit nicely with what I like to do, which is, until I'm proven wrong, I think that I should try. And so we actively were defending foreclosures during that crisis, and we have done a ton of student loan work in getting rid of that debt. And it's working. It's working very well. It's working more so even now under the current administration, but we had it working in the last decade or so as well.
This is very interesting. You may not know this about me. I don't know how often I share it publicly, but I went through personal bankruptcy myself. So I was married, got divorced, and after the divorce, I had some issues with child support being set too high. Lost my 6-figure IT job, ended up working as a paramedic, getting, a salary of $35,000 a year, lost my downward modification action in court, and I had to continue paying. It was over $30,000 a year in child support that I was paying, and I was only making $35,000. Well, paramedics with overtime can make a little bit more than that. But I also was on the hook for a certain percentage of private school tuition, where the kids were being raised Jewish Orthodox. It was a mess. And I basically lived off of credit cards, and just continued to live off of debt as the American consumer can, when situations like that happen, until I ran out of credit and ran out of the ability to pay to make minimum payments on those cards, and ultimately ended up going through a Chapter 7 bankruptcy. And it's very interesting because my attorney did talk about student loan debt and let me know that it's not forgivable and we have to exclude it from the bankruptcy. And I still actually am carrying some of those loans today. So, and it's been, what is it? It's 15 years since, since I went through that bankruptcy. So it's wild. Well, some of it was accrued after. So I went and got my MBA after I went through the bankruptcy, but some of it was my undergrad, which was before. And it's just wild to think, when you're in your introduction and you're saying, yeah, that, there are ways out of it. Well, tell me more.
Well, one thing you raised when you said private school tuition and the fact that you'd filed a bankruptcy before, one of the unique things that we are doing and have been doing for a little while now is, I don't know if you realize this, but in 2005 and 6, the bankruptcy code was amended, and it basically brought private loans into a non-dischargeable status, much like federal loans. So people who couldn't get out of student loan debt. So what did the marketplace do? A bunch of lenders out there thought, well, I'd like to lend money. I don't care what the money's used for. Let's go ahead and let that person buy a car, go on vacation, pay other debt, whatever. We don't care. But we want to call it a student loan because if we do, it's non-dischargeable in a bankruptcy. So we have a lot of what I call non-qualified education loans. They're basically things that the other side is calling a student loan, but they're not. They're beyond the cost of attendance. Maybe they went to an ineligible school, a vocational school, a helicopter school. We see a lot of that. We can get rid of that in bankruptcy. And in fact, if we run across that, we often take a little bit more of an aggressive stance, and we argue that any collection efforts after the bankruptcy is in violation of certain collection laws that allow us to get damages and perhaps a refund of monies that were spent post-bankruptcy to what would be a non-educational loan, because it was never used to actually pay the cost of education. It wasn't school certified. It was basically checks that people got while they went to school that they used to pay whatever, whenever. And that should be something that's subject to bankruptcy, just like a credit card. So we're doing those private student loan discharges. I don't know if you knew this, but down in the Mediterranean, or not Mediterranean, Caribbean, you've got about 50 different medical schools. Most of them are ineligible for federal financing, which means people take either private loans or they fund it through family money. Well, most of those private loans we can get rid of. And that's something that's not shared widespread. So that's something you can do with private loans. And with federal loans, you hear about the Biden administration, the new Secretary of Education. There's lots of stuff going on there. And we can get more into that, whatever you like.
Yeah. So there's actually two approaches I want to take to this conversation. I don't want to focus necessarily on somebody who can't make the payments. I think that most of our listeners are probably paying on their debt. Okay. So I want to take a two-pronged approach. Number one, for our listeners that are currently carrying student loan debt, which may be a lot of them, I want to talk about, are there strategies or options for them to be able to reduce or get out of the debt that they have without going through a bankruptcy, because they may be okay in their financial standing, but they're making these massive payments. They're basically carrying a mortgage, right? Like that's what I hear from a lot of people is like that, my student loan debt is a mortgage. The second route is for our attorneys who are serving people who carry student loan debt. So our bankruptcy attorneys, our estate planning attorneys, any other practice area that we can think of, family law, where student loans are an issue. Are there opportunities for them that they are missing by ignoring the student loans as opposed to leaning into it and helping their clients, maybe in the way that you are, or maybe in other ways? So those are the two directions I want to take our conversation. So let's focus on our audience first, and let's just talk about, are there options? What can they do with their debt, restructuring their debt, getting out of their debt, assuming that they're current on their payments?
Sure. Many of our clients are actually attorneys. Not all, of course. We have a wide variety, but we've done seminars for the Florida Bar and the ABI that a good majority of the attendees were attorneys, and then a lot of our clients are attorneys as well. And so many of them are actually paying their student loan debt. Where we run into the problem is, like you mentioned, the student loan debt is huge. It takes too much of their income, and it keeps them from doing other things with their life that they might want to do, starting a business and all that. So rather than go through the problems, the solutions that we're seeing out there right now, because we hear a lot about the problems, just, open any newspaper. We don't really have newspapers anymore, but watch any newscast and you know all about that. The solutions are, first of all, public service is now working. So if anyone out there has ever worked public service, if you have been denied forgiveness because you had the wrong loan type, you're in the wrong loan program, a number of different reasons like that, that's been fixed now. But we need to change your older FFEL, F-F-E-L, it stands for Federal Family Education Loans. We need to change them to be a newer direct loan to make them eligible for some of the new stuff that's out there. One of the new things that I did want to bring attention to for everyone listening today is there's an IDR waiver program. Now, it doesn't have a flashy name. Most people don't even really know what it is. But basically, we've had clients who have been in forbearance for years. Forbearance is where you call your servicer. You say, hey, I'm having a hard time making my payment. What can I do? Instead of directing you towards the public service program, disability, or perhaps income driven, they'll instead just offer a quick forbearance, no paperwork needed. You can do it on the phone. It's super fast. Everybody loved it. Problem is the balance keeps getting bigger. It snowballs. And so those forbearances, the extended ones, will now be counted towards an income driven plan because they probably should have counted back in the day, but they were never ever discussed. And so the IDR waiver program allows anyone with a direct loan to now get a one-time account adjustment so that if they have been paying on the loan for 20 or 25 years in whatever program they might have been in, including extended forbearances that maybe they shouldn't have been on, they're going to get credit for that time now. And their loan may be completely wiped out. And that's after making payments for 20 or 25 years. Or they may have a small residual amount left. That's huge. And we see a lot of older folks out there with the FFEL loans, FFEL loans that won't qualify automatically. So what everyone needs to do is go on studentaid.gov, look and see what you've got. If you've got any FFEL loans, then maybe reach out to someone like myself. Make sure that you do what you need to do to get them consolidated to make sure that you're eligible for this program, because it could mean, tens of thousands of dollars taken off your loan and maybe the loans are gone. Public service is working now. They're counting those payments. As long as you have a direct loan, they're now counting it. Let's say the payment was less than what it needed to be by just a few dollars or even a few cents. It wouldn't count. Well, now it does. Let's say it's a little late or it's paid ahead status. They count now. Let's say it's the wrong payment plan. You're on extended or some other type of fixed arrangement instead of an income-driven plan. Well, they count now too. There's all kinds of payments that were made that were not eligible for public service. Now they're eligible. So I don't want folks to give up on that. We had an attorney, I think it was last month or so, that I talked with, and he works in private practice now. But at the time, he had completed 10 years of public service, but not got credit for any of the years he had because he had the wrong loan type. So we changed him, and now he's eligible. And then he ended up getting a full forgiveness. He made, $200,000-300,000 at his current job, but he was entitled to forgiveness based on the prior public service that was previously denied. So that's going on out there. So what you hear in the news is this $10,000 forgiveness. That's a drop in the bucket. What we're doing is really getting rid of usually hundreds of thousands. The 10,000 is nice, but it is under appeal. We don't know if it's going to go through. Probably it won't, actually, but it's just a small part of what's going on right now. And I know there's a lot of people who may not believe in some of the forgiveness, but what the programs, the fixes, other than the 10,000, what these different fixes are designed to do is eliminate a problem that has existed for probably a very long time. Like I mentioned, public service, 1% of those who filed applications would actually get them approved. That's abysmal. It's just ludicrous that that was allowed to happen. The same thing with forbearances. You would have people on a 10-year forbearance. What good is that? That's not really helping anyone. So these things are designed to fix some problems that we've had.
Yeah, and I'm, it's interesting. It's tough for somebody who's in the camp of having student loans to be against student loan forgiveness. I'm not a fan of just blanket forgiveness, but I do think that there should be a way to come back and say, hey, income driven, or low income, maybe we make payments for you kind of thing. Or the public service where you said like 1% of those applications are being approved. People are working in public service in order to get that loan forgiven. Right? They're making that decision, and now they've given 10 years of their life, and you're going to make it difficult for them to get that, to get that approved. Definitely, that's something that, should be fought and should be won. So I'm glad that you're doing that work. I know that there was some sort of deadline last year in October for somebody who wanted to do the public service, that they had a one-time opportunity to consolidate their loans and then have something count retroactively. Do you know what I'm talking about?
I do. The deadline you're talking about was October 31, and that's for anyone to file a public service loan forgiveness application as well as convert their loans to direct. In a way, this IDR waiver program that I'm talking about offers a backdoor to do that. You can still consolidate your FFEL loans to direct, and they will be eligible. What has expired under that October 31 deadline was anyone who is no longer working public service. They, for instance, like let's say someone worked public service in the 90s or 2000s, and they were a few months shy of the 10 years. They would have to go back and complete that few months in order to get the discharge because that portion has expired. But anyone who's still working public service, they can backdoor through the IDR waiver, convert their loans to direct, get credit for all that time. And they are, of course, they're eligible for public service because they're still working public service. So once they complete 120 payments, which is 10 years, it is discharged. So that deadline was only for those who are no longer working public service. But we have clients who, if you're faced with 200,000 and you only have a few months left, you might take a sabbatical from your position, go somewhere else, complete those few months, and or do whatever it is to get that discharge. So there is ways to still get around that. The IDR waiver program that I was emphasizing to you, that expired May 1. They've just announced that it will be moved until the end of the year. I believe that's because the Department of Ed has indicated that since their budget wasn't increased, that they don't really have the manpower or funds to do all the things that they're required to do under these mandates. But I don't recommend waiting to the end of the year. And here's why. The FFEL loans that are being consolidated to direct to be eligible for forgiveness, they're usually commercially held. And so right now, they don't have much standing in order to contest this. But come May 11, when the COVID emergency expires, and when we have the final rules, the IDR rules that are expected any day now, you'll have a position where those commercial lenders can then appeal and sue for trying to stop that $200 billion of forgiveness that's anticipated under this program. So I would, and I just wrote a blog about this today. We do have a free blog on our website there at ChristieArkovich.com. I recommend people file it now. Don't wait till the end of the year because the landscape could be different. This IDR waiver program could be under appeal. I frankly am getting to the point where I'm be surprised if it's not. And I get it while it getting's good. So I do it now.
Now, if somebody doesn't have FFEL loans, they only have direct loans, do they need to do the IDR for any reason?
Okay, so for those, it's automatic, and so for those who have direct loans, they don't have to do anything in order for the one-time account adjustment to apply. What they need to do is take a look at the new repay. It's the IDR waivers. The IDR forgiveness. Think of it as an umbrella. It's over all the different income-driven plans. So you have IDR, income-driven plans, as the umbrella, and under it you have IBR, pay, repay, ICR, even ISR, although we don't usually see that anymore. Repay is a 10% program. It's the one that a lot of folks have used throughout the years, but it requires a spouse's income to count. The new repay does not, at least that's the way it's currently worded. It also has a lower payment. The old repay was 10% of someone's discretionary earnings. IBR, which was a very common one for FFEL loans, was 15%. So you had 10 or 15% of your earnings. Now it's going to be 5%. For an undergrad loan, it's 5%. For a grad loan, it's 10%. It's average between them if you have both types. On the case studies that we've done, it looks like the student loan payment under an IDR repay, under the new revised repay, is going to be about a third of what it probably was before. I mean, it'll be a little different for everyone, but it's averaging about a third of that. So we've got a lot of attorneys out there that are making pretty decent income, but they're having a hard time even making the IDR payment because they also maybe are putting a kid through college. Maybe they have a house payment, a car payment, maybe they have their own business. They can't do it all. And so for them, even though they might be making $100,000, they may see their IDR payment drop by 2/3. And then it would be probably quite affordable for them. That in addition to getting credit for several years that never counted before. So with the combination of that IDR waiver automatically occurring before the end of the year, as well as the new repay, they may have a very manageable federal student loan, even though it might be $200,000 or $300,000. The payment itself might be very manageable.
So once you're in the IDR program, you're automatically going to have that previous history looked at and some of that money waived, or you need to go through a formal application process?
Once you have a direct loan, you don't even have to be in the IDR program. If you just have a direct loan, it will automatically be reviewed for this one-time account audit. And it's called the IDR waiver program. It has a weird name for what it is, but it's a one-time audit that they'll be doing on all direct loans. And it's going to happen automatically for those with direct loans. Where the
it only affects somebody who's gone through forbearance at some point.
No, it also affects those that may have been making payments and they're just not getting anywhere. Like, let's say that you've switched different payment plans and so forth, and you've been making payments for 20 years or 25 years. Maybe some of it's been in extended forbearance. Maybe others have been different types of payments. Now the loan will be completely forgiven after 20 years for undergrad and 25 for grad loans. What that means is we had a lot of folks, for instance, when I graduated back in the early 90s, I was on a 10-year repayment plan, very typical 10 years. Somewhere along the line, it shifted to 30, and no one really told everybody. And so there's a lot of folks out there that they know how interest works, they know, all that, but they never really realized it went from 10 to 30 years. So come 10 years, they realize I've made almost no payments on my student loans. I paid all this money and I owe practically the same amount, if not more, than what I did when I graduated. Once they get to 20 years for undergrad or 25 for grad loans, any remaining balance will be discharged. So we have a lot of folks who have an older loan from the 80s even or 90s. They're going to be at that 20. I mean, we're 2021, right? Or 2023. Sorry, I've skipped 2 years somehow. 2023. So if you had been paying on that loan for enough time, you would be forgiven now. So that applies for that.
Yeah, 1998 was 25 years ago, right? It's really not going that far back.
Yep.
It's very interesting. So, what's that?
It seems like yesterday sometimes.
Yeah. Oh, no, it does. It absolutely does. I have a child that was born in 1999. So it's like, yeah, it wasn't that long ago. It just flashes before your eyes. Public service for a moment. Does it matter full-time, part-time, in and out? Like if somebody worked in public service, then they didn't work, or they held a, like they worked at a regular law firm, but then they also did 10 hours a week or whatever in public service. How does that work?
For forgiveness, what counts is anything that's full-time, which is defined as 30 hours or more, unless the employer has a different designation. The employer has to fill out a certification form that says full-time. So you can work 2 full-time jobs. A lot of folks do, actually, especially with remote work now. But it does have to be full-time. It has to be for a state, local, or federal government, or a qualifying nonprofit. And there's a form. You can fill in the form. They actually get back to you fairly quickly on that as to whether or not your employment counts, so that you'll know right away. It doesn't have to be consecutive. So we've had folks work public service for 2 years, out to private for 3, work public service again. All that counts. It can be multiple employers. It could be 2 full-time jobs at once. I've never really seen that, but that could happen. It didn't used to be religious, but now they have some rewriting of the rules that allows that. I'd have to look back at some of the more specifics, but a lot of the time counts.
And it goes by when you start repayment, right? Like, so it's not from when you were carrying the loan, but it's from when you started repaying the loan.
When you started repaying it, when you entered the program, basically. Yep.
Okay.
And you don't have to file the public service forgiveness app ahead of time. As long as you have an employer willing to fill out a form that you've worked public service for, 120 months, basically, and you've been making payments under an IDR for that time, or if your payment history counts now under the new rules, you'll be eligible for forgiveness. You don't have to have filled out a prior public service application. That being said, it's usually a good opportunity to do so, because the application itself has the employer certification. You get back a nice letter that says, oh, here's how many payments I have so far. Here's how many payments I have to go. You find out that your loans are qualified. I always think that's a good idea, particularly for those people who don't know a lot about their loans. They need to know ahead of time, is this going to happen for me or is it not? If it's not, I need to fix it, or I need to do something different.
Yeah, very interesting. And it's also interesting that it goes by the employer designation, because what if you're part-time, but you work full-time hours? If they're not calling it full-time, it won't count.
It may not count. It's something that, like I mentioned, if it's 30 hours, even though the employer may not count it, it is possible. But the employer has to sign off on it. So that would require some additional efforts to try to convince the employer to sign off on it.
Got it. Okay, so let's switch gears. We focused a lot on our audience getting their student loans lowered, reduced, and we're now moving into, okay, so what if we have clients that are carrying student loan debt? Is there an opportunity for us to provide services to that client above and beyond what we're already doing to help them with that student loan debt?
Sure. A couple of things we haven't talked about are settling private student loans. So private loans are not eligible for any of this government federal stuff we've been talking about. What we usually do for those is we look at how collectible they are, some other issues with standing, perhaps the statute of limitations and things. But if we settle a private student loan, doing so before the end of 2025 makes it tax-free. And so that's pretty worthwhile, because if we settle for 30 cents on the dollar, they don't get a tax bill for the other 70% if the payments and settlement occur before the end of 2025. So that's where we're focused some of our efforts in this upcoming couple of years, is to try to get as many people under that as we can. Other things with loans is that the bankruptcy aspect has just changed. We've always had this test called the Bruner test. It's a very difficult 3-pronged test that says, what someone needs to show for an undue hardship to discharge a federal or even a private student loan. We've taken that approach of it being a non-education loan for private loans, but what do you do with federal loans? Well, the Department of Justice has just announced in November that they have a new process whereby someone can file an adversary proceeding in bankruptcy, and they fill out an attestation form. So it's rather lengthy. It's like 15 pages of form as to what all their problems are. It's what I like to say it is, and why it is that they are entitled to a discharge. That process is just rolling out now. We've done a couple of webinars for the ABI. I know the Department of Justice has had a couple out there as well. NACPA has as well. And so we expect to see a lot more folks applying for and obtaining a discharge of federal student loans through that new DOJ process. It'll just be rolling out pretty much now. The other things are, we aren't allowed to use the FSA username and password of the borrower. In other words, in order to see what someone has, the way to find out is to go on studentaid.gov, which is the federal government site. Someone's credit report, of course, you can get that. But we aren't allowed to use their FSA username and password. So we ask our clients we give them a screenshots as to what to do and how to pull that for us and get that over to us. But we look and see what they have, and then we try to find solutions for that. Do they have a disability perhaps? If they're not able to work a full-time job where they used to, maybe we are eligible for the total and permanent disability program. We have a physician with an occupational medicine specialty that assists us with those applications, and we've been very successful and love those. So TPD is what that's called. The public service forgiveness, the repay, the IDR waiver. Those are things that we basically provide advice and help our clients understand that these options are out there. So what other attorneys could do is they could have their clients pull their information from the studentaid.gov, see what they have, make those recommendations, point them to information about what they can do with those loans if they don't do it themselves. We have a bunch of free information through our blog on our website, through our YouTube channel, Student Loan Sidebar. And we write it from an advocacy point of view. So in other words, here's what you can do, how you can do it, what it looks like, how long it takes. It's a little bit better, I think, than maybe the deer in the headlights type reaction that someone might have if they just go on the government sites. They can be confusing. Some of the information out there is contradictory because you have the old rules, you have the new rules. Once the new rules expire, it's going to go back to the old rules. So they haven't really been removed because once again, they'll be effective someday. So it gets a little confusing. And just being able to help your client understand what they have, understand how it impacts them. Like for instance, we've had clients in the past who have said their servicers say that their children will be liable for their loans after they pass. Well, that's not true. The federal loans die with them, but yet we've got servicers out there that aren't telling folks that. So just giving them accurate information about what they have and what the recourse is, they can help their client avoid garnishment of wages. They can help their clients, get rid of the debt so that's off their credit report. We have a Fresh Start initiative that is starting now with the federal government that someone can cure a default that they might have had for years, even though there may not be a mechanism to cure that default available anymore. I won't get into all the details on why and what for, but helps people buy houses because it takes the default off their record. And then lastly, settling those private loans.
And when somebody settles, does that go negatively against them in the on their credit report?
It's both good and bad. It is a settlement. So of course it has a negative connotation, just like any settlement would, but it also removes the debt from their credit report. So it increases their loan to debt ratio. So it's both good and bad, I believe.
Hmm. Have you ever encountered a lender that was willing to do a settlement with delete? That can commonly be done with credit card companies where you're like, okay, we'll settle for this amount, but the condition of the settlement is that you're going to delete the reporting completely.
If we can point out that there was an error. So in other words, if it was reported after a bankruptcy perhaps and it shouldn't have been, or if there was an error in calculations, there are times that we have a settlement where the original debt is still listed. And so that is an FCRA claim, usually a lawsuit that we'll bring. And so, yes, if there's an error or it shouldn't have been on there, if it is correctly reported and it was delinquent and then settled, there's probably nothing we can do to get that off if the creditor wants to keep it on there. It would be accurate.
Okay. I don't know if there's any questions I didn't ask you. We're running out of time. I'm going to close out the show, but is there something that we should have discussed that we didn't?
Let me think. We've got public service. We've covered quite a bit. I mean,
we did
quite a bit. I would just encourage anyone to check out our YouTube channel. We do hopefully post regular updates on that. There's different things that come out every day, every week, every month on these things. And so what might have been true 6 months ago, it may be entirely different now. And so don't just assume that nothing can be done. I've always said that. And now more than ever is the time to address student loans, because we don't know what the next administration might be. It may reverse some of the things that have happened so far. And if we can get a discharge now, that will remain. Whereas if we have a pending application or one hasn't been filed yet, that relief won't happen. So, food for thought.
Yeah.
But thank you for the opportunity. I did want to get out to your listeners because a lot of folks, they don't think anything can be done when in reality they can. If folks just want to check out our reviews, they'll see client after client talking about their debt is no longer there. They're able to do this, that, and the other thing. And it's real.
Yeah, and it makes a difference for our listener base because as owners of law firms, one of the main things that we have challenges within the business is cash flow and access to capital for growing the business. And part of that is driven by how much of the money do I need to take out of the business to pay for my own personal expenses. A lot of our goals are set based on what is our personal income requirements. So how aggressive we're building the firm, how much cash we're pulling out of the firm, all it backhandedly is directly related to this nut of student loan payment that I'm making. So if I can get a lower payment, if I can eliminate it, that will have a trickle down effect to making things easier on the business side, whether it's giving you more capital to put back into the business, or whether it's just relieving the stress of how much income you need from the business in order to live your life. So definitely very relevant to our business owners. I'd like to close out the show with two things. Number one, what is one piece of advice that you want to leave, parting piece of wisdom you want to leave with our audience? And number two, how can they take a next step with you if they want to learn more?
Okay. First of all, parting advice. Make sure that you know what you have in loans. You take control. Don't trust the servicer to do so, because there's been studies, 62% of them, they end up saying the wrong thing anyway. So you need to know what you have. If it's an income-driven plan, for instance, you can control the type of income that hits your tax return through retirement benefits and other things, how you file your taxes. As long as you know what you have, you take control, you create a plan of how to deal with your debt. And how to reach us, ChristieArkovich.com. You can also Google Arkovich Law. Our office number is 813-258-2808. We have a process. We set up a consultation. It's an hour-long conversation with an attorney. We do charge for that. It's fairly small compared to what the overall debt is. And we can give those solutions. Our clients can then do it themselves. They can hire us to do whatever it is. And if there's nothing to be done, there are times that we don't even charge for that if it only took 5 or 10 minutes, just to give our client peace of mind that they've done everything that they can do.
I love it. And we're going to link all that information up in the show notes. As mentioned at the beginning of the episode, folks, we're here every single week bringing you amazing guests just like Christie. This is a great conversation, and I'm excited for what's coming down the road, what's going to be next week, the week after. So if you're not subscribed to the channel, make sure to hit that subscribe button so that you get notified when we release our next episode. And as mentioned at the beginning of the show, we have our YouTube channel now. Go check it out, Profit with Law on YouTube. We'd love to have you as a subscriber. Different content being released on the different mediums. And the more that we can help educate you and direct you in the growth of your business, the more successful you are and the happier we are. So take care, enjoy. Make sure to keep that focus on your profitability, and we'll catch you next week.
Thank you for the opportunity. Have a great day. All right.
You're welcome. Have you been enjoying the show? We sure hope so. To make sure you never miss an episode, be sure to hit the subscribe button in your podcast player app. Next week, we will be back with more valuable resources and ideas on how to break the mold and take your law firm to the next level.